Let's start with the immigration status that's making its way through the court system right now. DACA, or Deferred Action for Childhood Arrivals, is an immigration policy that started in 2012, often referred to as undocumented immigrants or dreamers. Those with DACA status are protected from deportation, and some are allowed to work legally in the U.S. According to U.S. Citizenship and Immigration Services, there were about 580,000 recipients nationally as of March 2023, with around 14,300 in Washington state. Opponents have filed multiple legal challenges trying to strike down DACA since its inception. As of January 2025, a federal judge has ruled that DACA is illegal, but the program continues as the courts sort through appeals. President Donald Trump fought to dismantle DACA during his first term, but his stance may have shifted as he has recently said,
"You want them to be able to stay, that's what you're saying?"
I do. I want to be able to work something out.
Another immigration program that affects us here in Washington is Temporary Protected Status, or TPS. As of March 2024, there are more than 860,000 people holding TPS in the U.S. This status provides temporary relief to foreigners who are unable to return home due to threats from war, epidemics, or environmental disasters. TPS recipients are protected from deportation and allowed to work in the U.S. while they are here, and they can reapply for this status as long as their home country is on the approved list. While TPS itself cannot be dismantled without congressional approval, President Trump can instruct the Secretary of Homeland Security to take certain countries off the list. This next category is a visa. The H-2A visa is given to temporary agriculture workers who want to find work in the United States. Many producers in eastern Washington utilize this visa to hire workers for the growing and harvesting seasons. The visa can last from a month up to 10 months. While the Trump administration has not said anything specific about the H-2A visas, Project 2025 has proposed potentially stricter guidelines in the application process, which is something ag industry representatives have said they are concerned about in eastern Washington. This brings us to whether crossing the border illegally is a felony or a misdemeanor. According to Title 8 U.S. Code Section 1325, first-time illegal entry is typically a misdemeanor that could bring fines and prison time of up to 6 months. A second illegal entry can be a felony that comes with fines and prison time of up to 2 years. It gets complicated when you re-enter the U.S. after officially having been deported. Then it is a felony with penalties that depend on criminal history. So calling someone who has crossed the border illegally a felon is technically incorrect if it is their first time. When you come to the U.S. on a valid visa but stay after the visa has expired, that is considered unlawful presence. You also have unlawful presence if you cross the border and stayed without proper documentation. There are a few exceptions, though. If the person was brought to the U.S. illegally as a minor, they might qualify for DACA. A person may also qualify for certain protections and visas if they are a victim of abuse or human trafficking. With the upcoming Trump administration, it's difficult to predict what might happen to dozens of different types of visas, statuses, and programs that all fall under the immigration system. But knowing the different types that we most commonly hear about may help you navigate the issue with clarity. For Facing Race, I'm sharing you with photojournalist Rachel Kim, King 5 News.